Okay,
Oh shit.
let's go ahead, everyone here. Let's go ahead and, I think we have, what's it, Wishoff, Phantom, correct? Mr. Wishoff,
Can you hear me?
is it, where is he?
I don't know. If you tell. I'm in the waiting room.
Oh, he's in the waiting room, Your Honor.
Okay,
Sorry.
Your Honor, this is Johnny Carter. I clicked we don't want to join computer audio. I think I created a tech problem for myself, which we're working out here just so I can get the video back.
okay.
All right, there we go.
All right, you can proceed.
All right, Your Honor, and we will ask for the remainder of cross of Mr. Wishoff today if we could have the screen sharing access just to share exhibits.
Sure, let me do that right now. There you go.
Okay. Mr. Wishoff, welcome back.
Good morning.
Do you recall that the last question you were asked yesterday by Arms Counsel was, what impact has it had on ARM that Medallion has kept this money, this prepayment, and drew down on the letter of credit?
I do.
You recall that you answered, the amount of dollars that they are holding has not allowed us to go out and find a replacement for this thesis that we had in place and won't be able to until we get those dollars back. Do you recall that?
I do.
You were testifying about obtaining replacement pipeline and terminal capacity, right?
Yes. Or
On April 4th,
or additional other businesses.
I'm sorry.
on April 4th,
I couldn't hear what either, you guys kind of talked over each other. What did you say again?
Oh, I was saying, or additional other businesses.
on April 4th, 2022, 9 months ago, ARM bought the Monument natural gas pipeline in the Houston area, right?
ARM Energy Holdings created a new company that bought the pipeline. Yes.
ARM paid a total consideration of approximately $203 million for the Monument pipeline, right?
I believe that's correct. Yes.
Let's look at Defendant's Exhibit 165. Defendant's Exhibit 165 is an email dated March 8, 2020. Do you see that?
Yes.
This is about 3 weeks before commencement of services on the EPIC pipeline, right?
Yes.
It is an email from Veronica Lewand of EPIC, right?
Agreed.
She sends the email to dozens of people, right?
Yes.
She sends it to Dave Cook, the General Counsel of ARM, right?
Yes.
And Josh Sharman of ARM, right?
Yes.
Also Lauren Mitchell of ARM, correct?
Yes.
And there's you. You received the email, correct?
Yes.
And then also we see Shannon Flowers of ARM and ARM's president, Taylor Tipton, right?
Yes.
In this email, 3 weeks before the commencement of services, Ms. Lewand lists the, she says, please find some key information about the system. All points are deemed active unless otherwise stated. And then she lists some receipt connection points. Do you see that?
Yes.
One of the receipt connection points is Wink, Delaware Crossing, previously SCM. Do you see that?
Yes.
SCM, as we discussed yesterday, is Salt Creek, right?
Yes.
Salt Creek was being operated by ARM, right?
ARM was the operator. Yes.
Delaware Crossing, that is referred to there as previously SCM, was a joint venture of Salt Creek and Noble Energy, right?
Yes.
Delaware Crossing, the joint venture that Salt Creek was involved in, was looking to commission with WTI. In April 2020, right? Yes.
Epic was looking for commissioning of WTI in 2020 at Delaware Crossing.
Okay. It says looking to commission with WTI in April 2020 at this time only. Do you see that?
Yes,
And you know that the Delaware Crossing tariff was, in fact, WTI throughout the period of April 20 to April 2021, right?
I'm not intimately familiar with their gathering contract now.
Okay. You are not familiar with the quality specifications in the Delaware Crossing pipeline that was, for the Delaware Crossing pipeline tariff that was going to connect into the Epic pipeline, right?
AEM was not a shipper on that, so I didn't have a contract on that pipe.
Epic did not control the tariffs of the pipelines that connected into Epic, right?
That is correct.
Delaware Crossing was a different company than Epic that could have its own tariffs with their own quality specifications, right?
That's correct.
Ms. Lewin asked the group, the dozens of people who received this email, please advise of interest to ship WTL. Do you see that?
Yes,
You never responded to this email, right?
I did not, because we do not have a contract with Epic.
And you were not aware of anybody from ARM who received this, the 6 people from ARM who received this email, you're not aware of any of them responding to this email from Veronica Lewin of Epic, right?
Not to my knowledge.
I move admission of Defendant's Exhibit 165.
Defendants 165, okay, any objection? Defendants 165.
No objection.
Defendants 165 is admitted.
Real quickly, Your Honor, before I move to the next exhibit, I'd like to see if I could get the screen set so that I can see the full exhibit. Sometimes, Your Honor, the thumbnail where you see the witness in the court is will block the exhibit. There we go. Perfect. So now let's take down Exhibit 165 and let's look at Plaintiff's Exhibit 77. You see Plaintiff's Exhibit 77?
Yes,
Arms Counsel asked you about Plaintiff's Exhibit 77 yesterday, right?
I believe so, yes.
We look on the second page and we look at the email dated April 3rd, 2020. Veronica Lewin of Epic emailed you, Josh Sarman of ARM, and some folks from VTOL directly about Epic, saying Epic no longer intends to offer WTL service. Do you see that?
Yes,
Epic asked in this email, Epic asked its committed shippers to forego submitting nominations under these common streams until further notice. Do you see that?
yes,
From this day forward until the termination of the agreements between ARM and Medallion, Epic did not offer or provide WTL common stream service on its pipeline, correct?
they never accepted the WTL nominations.
Right. From Glencore or any other shipper during the time that from April 2020 to April 2021, correct?
They never went into WTL service to accept WTL.
Right. They did not offer or provide a WTL common stream during that time, right?
The common stream was in the tariff. However, they were not accepting nominations for WTL.
Right. 4 days later, you forwarded this email to Mr. Lastman at Medallion, right?
Yes,
You had to forward the email to Mr. Lastman because Mr. Lastman did not get the email from Epic, right?
I did not know at the time. I wanted I wanted him to be aware of it and discuss this email.
And if we go up to the email above it, the response from Mr. Lastman, in fact, told you, I have not received this, correct?
Correct.
And Mr. Lastman asks you, what are you guys / Glencore thinking, right?
Correct.
We go up above to your reply to that. You told Mr. Lastman, we weren't shipping WTL this month or next anyway, as they said they wouldn't be ready until June or July. You see that?
Yes.
The they that you are referring to there is Epic, right?
Via our medallion contract.
Right. Epic had told you they wouldn't be ready until June or July. Right.
I believe at some point Mike Glassman had told us that as well.
Epic had told you that they would not be ready until June or July, right?
Epic's in an email, which I believe Mike Glassman said the same as well.
Okay. In the next sentence, you wrote, we think that this is just a short-term workaround from what they have said outside of the email, so they don't have to file with the FERC. You see that?
Yes.
Epic told you outside of this email that they would not have service until June or July, right?
I don't know if they told me directly, but there was conversations that was going to be the case.
Right. Epic had conversations with ARM and had advised ARM, even outside of this email, that they were not going to have service until after the commencement as a short-term workaround, correct?
We were, people within the company had that information, yes.
Yeah, people within ARM had that information, right?
Yes.
Mr. Lastman then responds to you at the top on April 8th, 2020, correct?
Yes.
One of the things Mr. Lastman says is that their problem is, well, he says that he talked to Epic that morning, right?
Yes.
And then he tells you that their problem is that they don't have much WTL coming in at Wink/Orla, and the batches would be so small, they thought it might be difficult to do. You see that?
Yes.
You did not have any reason to disagree with the statement that Epic did not have enough WTL coming in, right?
We weren't under the opinion that it would be flowing till June 1 at this time.
I didn't catch that. What was your answer?
We were not under the opinion that WTO would be flowing until June 1 at this time anyway.
Right, and you did not have any reason to disagree with the statement that Epic did not have enough WTL coming in and that the batches would be so small that it would be difficult to do. You had no reason to disagree with that, right?
I don't know if I agreed or disagreed. With the estimate one, we assumed it would flow June 1.
Right. You had no opinion on whether this would be difficult to do, right?
Not at this. If it wasn't going to flow until June 1, I think the belief was that there wouldn't have been anything flowing in April.
Right, but I'm asking a different question. You had no opinion about whether it would have been difficult from an operational standpoint to flow WTL in these small batches, right?
I didn't have an opinion. We were being told it was going to flow June 1, so that's what we were preparing for.
Mike Lastman gives you his, if you go down a couple sentences, he gives you a guess, right? He says, my guess is once that is complete, referring to an Oryx crane connection, they'll start batching WTL. Do you see that?
Yes.
And he says estimated to be June 1, correct?
Yes.
Which is the same information that ARM already had from Epic, right?
It was information we believe to be true, yes.
And you believed it to be true because Epic had told you, right?
Or they'd send an email, et cetera.
Right. And then in the next paragraph, Mr. Lastman says, do you want us to push back on this change with them? Correct?
Yes.
You don't recall ever responding to Mr. Lastman's question, right?
I may not have responded in email. I sent this letter to him to notify him that we are interested in discussing this. And I believe that there were subsequent phone calls between Guy Freshwater and Mike Lastman regarding this.
You think that two people that had a phone call that you weren't even on about this subsequently, right?
Or I was. We talked about this every month, I believe.
Okay. You don't remember ever responding to Mr. Lastman's email either directly or indirectly, right?
I did not send an email further to this chain, no.
Right. And you don't recall a phone conversation responding to his question after receiving this email, do you?
I don't recall specific, but this is a topic that we talked about every month. Or when is the start date going to be?
I'm sorry.
Let's look at plaintiff's.
So you keep trailing off when we can't hear you. You got to speak loudly the whole time. What did you say?
Play stat? Sorry, I'll move it closer.
What did you say at the end?
I said this is, I believe I was saying this is something that we were discussing every month when the start date was going to be.
Okay, let's take down Plaintiff's Exhibit 77 and put up Plaintiff's Exhibit 82. Plaintiff's Exhibit 82 is a set of emails from May 11th, 2020. This is a little more than a month on from the ones that we were just looking at, right?
Yes.
And if we turn to the next page of Plaintiff's Exhibit 82, do you see that there is an email from your colleague at ARM, Mark Walter, to Veronica Lewand at Epic? See that?
Yes.
And Mr. Walter says to Ms. Lewand, Veronica, has there been any update on when Epic will take WTL into the pipe? Do you see that?
Yes.
Mr. Walter did not send this email to Medallion, correct?
Mark Walter was a Salt Creek employee, so he would have had no reason to talk to Medallion.
Mark Walter did not send this email to Medallion.
Salt Creek had no deal with Medallion, so they would not have communicated.
I'm asking you on this email on the page, Mr. Walter didn't send this to Medallion, correct? My question now, sir.
I said he did not. He had no reason to.
Right. Mr. Walter, you say is a Salt Creek employee. He was also an ARM employee, right?
He was working for ARM as the operator of Salt Creek.
His email address is mark.walter@armenergy.com, right?
Yes.
Ms.
Lewand responded that same day to Mr. Walter, right?
I have a question for the witness. Why does it matter that he was a Salt Creek employee? Why wouldn't he talk directly to Medallion as opposed to Epic? Why? I guess I don't quite understand why you said it's because he's a Salt Creek employee. Why does that matter in terms of who he's talking to?
So the AEM contract, our contract, was with Medallion. Salt Creek had their own deals with Epic, which Mark Walter was discussing. So Salt Creek directly with Epic.
But Salt Creek was owned by ARM, right?
Salt Creek was owned by Aries.
Oh, that's right. And 3% by ARM.
ARM
right?
was the 3% minority owner and operator. So Mark, as a scheduler for Salt Creek, was talking about his contract directly with Epic.
Okay.
All of these folks, Mark Walter, Shannon Flowers, Taylor Tipton, Scott Wishoff, Josh Sharman, they all worked on ARM business and they all worked on Salt Creek business because ARM was under a contract to manage Salt Creek, right?
ARM was the operator of Salt Creek, yes.
So let's look at Ms. Lewand's response to Mr. Walter's email. Ms. Lewin tells Mr. Walter, "Hi, Mark. At this time, we are still working with shippers on moving WTI only. Market conditions are having significant impacts on crude supply." Do you see that?
Yes.
That was certainly true at this time. Market conditions were having a significant impact on crude supplies, correct?
Yes.
Then Ms. Lewin says, "Please do keep us aware of your interest and desire. Therefore, as market returns, we are best aware of shipper needs and can correspond accordingly." Do you see that?
Yes.
Then Mr. Burney of Epic also responds to Mr. Walter, right?
Yes.
Mr. Burney says to Mr. Walter, "Mark, we haven't any demand or interest from our primary shippers, so hit pause for a bit." Do you see that?
Yes.
One of Epic's primary shippers was, as you mentioned, Salt Creek under ARM's operation, correct?
Correct.
Mr. Burney asks Mr. Walter, "Does ARM want to start shipping? If so, how much volume do you want to send?" Do you see that?
Yes.
So Mr. Walter answered Mr. Burney's question about whether ARM wants to start shipping in his email at the top. Do you see that?
Yes.
In this email on May 11th, 2020, Mark Walter describes one of our producers that is bringing on new wells expected to start June the 1st. Do you see that?
Yes.
And then he says, their production looks to be sub 44 API, which would be WTI, correct?
Yes.
Then he says, but they are also going into a commingled stream, correct?
Yes.
So a commingled stream is a stream that might have different qualities of crude oil going in together, correct?
Correct.
He says, so the final product may be WTL, and we just want to present their options to them if the stream goes above 44, in other words, WTL, right?
Correct.
Mr. Walter's answer to Mr. Burney's question about whether ARM wants to start shipping WTL is, this is more of a hypothetical than anything else, just trying to figure out our options. Do you see that?
Yes.
Move to admit plaintiff's exhibit 82.
One thing to note on this is that Vitol was the manager of Salt Creek's capacity. So ARM would not have been shipping anything. It would have been Vitol, just a nuance.
Okay. Any objection to plaintiff 82?
No, Your Honor.
Plaintiff 82 is admitted. And who was saying this? That somebody just spoke about this being Vitol. How do you spell Vitol if you said that?
Yes, that was the Scott Wishoff. Vitol, VITOL. They were the manager of the capacity.
Vitol is an export firm, so they played a role with Salt Creek that has some similarities to the role Glencore played with ARM on its smaller deal with Medallion, right?
Correct.
Okay. Let's look at Defendant's Exhibit 131. This is a document produced by ARM dated June 24, 2020, where we have an email from Josh Sarman of ARM to Taylor Tipton, the president of ARM, and Zach Lee, the CEO of ARM, with a copy to Scott Wishoff. Do you see that?
Yes.
This is nearly 3 months after commencement of services on the EPIC pipeline, correct?
Correct.
Mr. Sarman tells you, and Mr. Tipton and Mr. Lee, that he had spoke to Veronica, correct?
Yes.
That's Veronica Lewin of EPIC, right?
Yes.
After talking with Veronica Lewin of EPIC, Mr. Sarman told you and Mr. Lee and Mr. Tipton in red, italics, and underline that Epic Terminal will not have their 40,000 barrels per day load rate until Q3 2021. You see that?
Yes,
That load rate is the new terminal load rate, right?
that is a load rate commonly associated with the Suezmax.
Correct. And that is actually the load rate that is listed in the terminal services agreement that you discussed yesterday with Arms Council for the new terminal, correct?
Yes,
After this discussion with Ms. Lewand, Mr. Sarman also told you underneath the reference to the 40,000 barrel per hour load rate, he said, Epic recently ordered the loading arm and it is not an off-the-shelf purchase. Do you see that?
yes,
And then he told you this is significantly delayed, correct?
correct.
In fact, he mentions here the visit that he paid to the terminal with you and the folks from Glencore in late 2019, correct?
Correct.
He says, when Scott and I were at the terminal in November 19, he may have got the month a little off, with Glencore, Epic stated it would be done by August to October 2020. And you recall we discussed that yesterday, that you had learned from Epic by then that there was a delay with the new terminal, right?
Yes, that was several months after our signing of the contract. We started to learn of delays.
Right. And then it said this was a major concern on Glencore's part. You see that?
Yes,
Largely outside of our control, however. Between late 2019 and June 2020, the new terminal commencement had been pushed off by an extra year, right?
we were learning in real time when this was happening, but it was being delayed, yes.
Right. Epic told ARM that the new terminal had been delayed an extra year, right?
I think they were estimating at the time, yes.
Right. And Epic was telling ARM that information in real time, correct?
Yes,
As we go down further, you see the bullet point 3 up from the bottom. It says the Orla SCM and Epic connection is finished, but Epic does not believe enough crude to fill the line and tank bottom. You see that?
yes,
Okay. And then he says in the bottom bullet point after talking with Epic that Epic continues to think that there is not enough shipper interest to ship WTL or enough crude for batching. Do you see that?
yes.
Move admission of Defendant's Exhibit 131.
The reason that is that Epic was late building the Orla interconnect, and that volume was flowing to Plains. It was no longer going into Epic.
Okay, I'm a little confused. So, wait. Just so we can kind of be clear on this. The witness has a tendency after there's a request to offer an exhibit to continue to speak. I need to be able to rule on whether or not that exhibit is admissible before the witness keeps talking. So you could just be aware, I need to be able to rule on that when they make an offer so that that can be clear on the record. Is this plaintiff's 131?
No, Your Honor, I believe this is Defendant's Exhibit 131.
Okay. Let me see real quick. Any objection to defendant's admission of defendant's 131?
No.
Defendant 131 is admitted. Okay.
And just to address the comment that was made after the request to admit the document, you testified that the reason for this delay with Orla was that the connection had not been made between Salt Creek's pipeline at Orla and Epic. That was your testimony, correct?
My understanding was that it was late and that the volume ended up going into Plains.
And we see in Mr. Sarman's email that he told you from the third bullet point up from the bottom of his email that, in fact, the Orla SCM Epic connection was finished, right?
In June, yeah, which was there were volumes flowing before June. That was the concern.
Right. The Epic Orla SCM Epic connection was finished, but there wasn't enough crude to fill the line and tank bottom. Do you see that?
There was not enough going into Epic at the time. There was crude on the SCM system.
And who was responsible for the line fill from Orla to Crane, from that connection down to Crane
In
on the
our
Epic
contract,
pipeline?
in our contract, it was the carrier.
I'm asking you, who was responsible for the line fill under the Epic tariff, if you know, sir, from Orla down to Crane?
In our contract with Medallion, it was the carrier.
Okay. You know that Salt Creek, the company that ARM was operating, was the only committed shipper for that segment of the Epic pipeline, right?
Were they the only? I do not know that that's correct or not. I thought everyone received the origin points.
I didn't catch that last sentence. I'm sorry.
I thought everyone received the origin points.
And so you don't know whether or not Salt Creek, the company that ARM was still operating at this moment, was responsible actually for the line fill from Salt Creek to Orla, I mean from Salt Creek at Orla to Crane in order to allow for shipment, correct?
The Epic pipeline carriers would have been responsible for that.
Okay, right. We can take that one down. You testified yesterday that by the time we got to July and August of 2020, the world had begun to stabilize, and we were looking at opportunities again as we came out of that. Do you recall that testimony?
Yes.
Arms counsel asked you about Plaintiff's Exhibit 96. This was an August 3rd, 2020 email from Hunter McDonald at Glencore to a number of folks at ARM and Glencore, summarizing a call between the folks from ARM and the folks from Glencore, right?
Yes.
In this email, on the second page, Mr. McDonald mentioned that the W2W Sealy 3 was commencing service early September. Do you see that?
Yes.
This was one more pipeline fighting for barrels from the Permian. You see that?
Yes.
Pipeline space is now trading this is space from the Permian to Corpus at variable cost, 10 to 15 cents per barrel, correct?
Yes.
This is about 10% of what Glencore was paying for Medallion's capacity on Epic's pipeline, right?
That they were paying to Medallion and that we were paying to Glencore, yes.
Then it says dock space also trading at variable cost since Corpus is overbuilt as low as 5 cents per barrel. Do you see that?
Yes.
That is about a third of what Glencore was paying for Medallion's capacity on Epic's pipeline. Do you see that?
Yes. And that AEM was reimbursing Glencore, yes.
And I misphrased it. This is about a third of what Glencore is paying from Medallion's capacity at Epic's terminal, right?
Yes.
And this was in August of 2020 when you testified things were beginning to stabilize, correct?
Yes.
Even by the time, we can take down that exhibit, even by the time that ARMS sought the temporary injunction on Medallion drawing on the letters of credit in April 2021, the market cost for walk-up service to get crude on Epic from the Permian Basin to vessel loading was still only around 30 to 50 cents, right?
That sounds correct.
that was substantially less than what Glencore had been paying, the $1.50 per barrel to Medallion, right?
It was less. We were reimbursing them for that, yes.
Let's go back to August 2020 and look at Defendant's Exhibit 230, which is a document produced by ARM. On August 31, 2020, you emailed a presentation to several people at ARM, correct?
Yes,
One of those people is Gil Burciaga, right?
yes,
And you mentioned him yesterday. He's a co-founder of ARM and chairman of the board, right?
yes,
You also sent the presentation to Michael Christopher, who is the CFO of ARM, right?
at the time, yes,
Right. And to Bo Dunn, who was a vice president of finance, right?
at the time, yes,
And Zach Lee, who is CEO of ARM, right?
yes,
You mentioned, you attach a presentation. The presentation is called AEM Quarterly Version 15, August 31, 2020, Scott Final.PowerPoint. You see that?
yes,
You're the Scott that is referred to there in the presentation title, right?
yes,
Because the presentation that you attached was your presentation, right?
yes,
Is for quarterly meetings that ARM would hold of executives to talk about their businesses, right?
correct,
This was the version 15, so it was the 15th and final version. It had been through a lot of drafts, right?
correct.
If we go back into the presentation, let's look at the page that is Bates numbered AEM 18541, and we may need to blow this up. The text quality isn't great. You have a slide in your presentation titled Medallion/Lillis. You see that?
Yes,
In this slide, you told the ARM executives that ARM did not ship in June, correct?
correct,
Right. That's over on the left-hand side, the bullet point about kind of halfway down. Did not ship in June. And then you told the ARM executives that ARM or Glencore did not ship in July and August, impacted by demand costs. Do you see that?
yes,
Demand costs are the money that was being paid to Medallion, right?
correct,
If we go down underneath that, it says to the next major heading, AEM, that's ARM, has line of sight to 10 to 15,000 barrels per day of crude oil to be put into the JV finalizing terms. Do you see that?
yes,
The JV is the JV between ARM and Glencore, right?
yes,
During this period of stabilization, ARM only had a line of sight on 10 to 15,000 barrels per day of crude oil to be put into the JV, right?
we had a line of sight of 10 to 15 to supplement whatever Glencore was buying, yes,
The total capacity in the agreement was 27,778 barrels per day, correct?
correct,
And with respect to that crude oil on which ARM had the line of sight, ARM was still only finalizing terms, correct?
in this bullet point, yes,
Okay. And then underneath that, you told the ARM executives that Ben Beckham is only salesperson actively soliciting barrels. Do you see that?
yes,
And then you told the executives that ARM, AEM, is continuing to evaluate opportunities to take the Medallion liability off the balance sheet. You see that?
yes,
Okay. Now, we've looked at the left-hand side of the page. This relates to Medallion and ARM and Glencore. But up at the top of the slide, remember it said Medallion/Lillis, correct?
yes,
So let's talk a little bit about Lillis. Do you see that on the right-hand side, the slide has a lot of information about Lillis.
Can we go back to something? Because I'm not sure I fully understand it. It says here AEM is continuing to evaluate opportunities to reduce to take medallion liability off the balance sheet. What does that mean exactly? That they're trying to evaluate opportunities? What opportunities to get out of the contract? Is that what they're trying to say, or what does that mean exactly?
No, what we had credit assurances due medallion. When Glencore stepped in, the contract was 18 months. And they took the liability and the credit assurances in that 18-month window. So what we are looking at was extending that deal with Glencore or others where they could come in and step in and provide the guarantee or the assurances. At the time, we were posting the dollars for prepay, and we were posting an LC, which affect our ability to draw on other things. And so
What is
we
an
was
LC?
in every business.
What is an LC? What is an LC?
Sorry, letter of credit.
Okay, sorry.
Yep.
Go ahead.
And so in all our businesses, we are a small employee-owned entity. In all our businesses, we're always looking at taking our assurances, parental guarantees, letters of credit, and moving them to a counterparty that can help us with those assurances.
Okay, go ahead.
Okay. Now let's look on the right-hand side of the page. Do you see that on this slide, if we look at the kind of the middle blue line, it says the Lillis purchase agreement would have offset 50% of medallion obligations. Do you see that?
Yes.
Lillis was a producer in West Texas. Do you see that?
I don't see that, but yes, they were.
That's the wrong question. But yes, Lillis was a producer in West Texas, right?
Yes.
Okay. And in fact, if we look up above this, your slide says that Lillis base-loaded AEM's deal with Medallion, providing transport from Midland to the coast. And ARB, I think that means arbitrage, right? Opportunities to the world.
Yes.
And then you wrote on your slide that the deal with Lillis was MEH minus 495 through December 24, and would have offset more than 50% of the Medallion $62 million obligation through September 25. Do you see that?
Yes.
ARM had a multi-year agreement with a producer in West Texas called Lillis, where Lillis committed to sell thousands of barrels a day to ARM at the price of MEH, which we'll talk about in a second, minus 495 per barrel, correct?
Yes.
Right. MEH is an acronym that is used that essentially means a Gulf Coast price, correct?
It is Magellan East Houston, which is a marker for the Texas Gulf Coast.
Right. And so by entering into this deal with Lillis, ARM believed that it was receiving, that it had a deal in hand by which it would be able to offset more than 50% of the Medallion obligation by buying crude oil in West Texas at MEH minus 495 and shipping it to the Gulf Coast, correct?
Yes.
And in fact, here you say Lillis production would have contributed up to $30 million of gross margin through December 24 against the $62 million total liability through September 25, correct?
Correct.
Right. And that $62 million total liability was the amount of money that was owed to Medallion, correct?
Through the term of the deal, yes.
Okay. I move admission of Defendant's Exhibit 230.
No objection.
Oh, excuse me, Defendants 230, any objection?
No, Your Honor.
Defendants 230 is admitted.
Now let's take down Defendant's Exhibit 230 and look at Defendant's Exhibit 221. Defendant's Exhibit 221 is an email from Josh Sarman of ARM to Taylor Tipton and to you, Scott Wishoff. And this one is called Medallion Scenarios, correct?
Yes.
Okay. Now I want to set the timeline a little bit because we're bouncing back and forth a little bit. So we're at December 18, 2019. We're a few months before commencement of services, but after execution of the agreements with Medallion, right?
Yes.
I didn't hear the answer.
Sorry. Yes.
Okay. And then this is a couple of days before the agreement was entered into between ARM and Glencore, correct?
I don't remember the exact date, but yeah, I assume that's correct.
Okay. We looked at a little bit, or Arms Council looked with you a little bit at the master crude oil agreement between ARM and Glencore. That was dated December 2019 or thereabouts, correct?
Thereabouts, yes.
You testified yesterday that before you can proceed with the deal, you need approval from an investment committee within ARM, correct?
Yes.
To do that,
Deals of certain sizes, yes.
right. To do that, you would send an email with some of the deal basics, often with the risk and conservative evaluation to notify them of what you were looking at, correct?
Correct.
In his attachment to Defendant's Exhibit 221, Mr. Sarman modeled financial scenarios for you and Mr. Tipton relating to the Medallion agreements, correct?
Yes.
And let's look at the scenario on page 14 of his presentations. Do you see that scenario?
Yes.
Do you see that it says Medallion Scenarios at the top, total current market value, correct?
Correct.
And then underneath there is at the bottom of the page after the chart, there is a summary, correct?
Correct.
And the first bullet point of the summary says AEM takes 100% of the Midland MEH spread, 40% of the MEH Brent spread. You see that?
Yes.
MEH being Gulf Coast and Brent being the word that is often used for overseas, correct?
It is the forward financial contract quoted for North Sea, yes.
And this is what you testified about yesterday, that ARM would keep 100% of the onshore deal, let me start over here. This is what you testified about yesterday, that ARM would keep 100% of the onshore spread, but only 40% of the export spread, correct?
Correct.
The second bullet point says that it would be effectively capturing 28 cents per barrel after demand costs and sharing, AEM Glencore, majority of the value from Brent. Do you see that?
Yes.
So under the scenario with the current market value as of December 2019, Mr. Sarman projected capturing 28 cents per barrel for ARM, and that is after having paid Medallion and after having shared 60% of the export spread with Glencore, correct?
Again, this is very conservative, only to Brent, not to Asia, not different qualities, but yes, it's correct.
Right. The model that Mr. Sarman prepared in connection with approval of the Glencore deal did not even mention Asia. It mentioned Brent prices for export, correct?
Yes, we always used Brent as that is the financial future contract that would be defensible to the investment committee.
On the bottom bullet point, we see that it says, during the tenor of the Medallion contract, AEM will net $13 million. Do you see that?
Yes.
By tenor, does that mean the length of the contract, 5 years?
Yes.
Okay. So this was the current market value projection from Mr. Sarman as of December 2019, correct?
This was his conservative model of December 19th value, yes.
This was before COVID, right?
This was before COVID, yes.
Now let's go to the last page of the presentation. You see the last page of the presentation says medallion scenarios Lillis.
Yes.
And he says the Lillis in the first bullet point transaction was intended to be structured around our medallion capacity. You see that?
Yes.
And then he said that this transaction represented about 11.3 million of annual gains, which could be offset to the medallion capacity payments. Do you see that?
Yes.
That's a reference to the Lillis transaction, correct?
Correct.
That is consistent with the discussion that we were having earlier about the value of having the multi-year deal for MEH minus 495 with Lillis, correct?
I believe that's where the dollar was derived from, yes.
With the Lillis transaction, using current market values, if we look at the bottom bullet point, the full value using current curves would be a $42 million gain. Do you see that?
Yes.
As compared to a $13 million gain that we saw for the current market scenario without Lillis, correct?
What he's referring to, yes, that's correct.
Okay. Your Honor, I move admission of Defendant's Exhibit 221.
Any objection?
No, Your Honor.
Defendant's 221 is admitted.
Do you remember, Mr. Wishoff, that yesterday you testified that we, referring to ARM, were not supposed to pursue customers on the Salt Creek system?
Yes.
Lillis was on the Salt Creek system, right?
Lillis was on the Salt Creek system, yes.
The Lillis deal was terminated in the spring of 2020, right?
I don't remember the exact date, but that sounds correct.
Okay. The Lillis deal was terminated and Lillis went bankrupt, right?
Yes.
And Lillis ended up in litigation with both ARM and Salt Creek, right?
I don't recall the details. That's likely correct.
Okay. Let's look at Defendant's Exhibit 233. Defendant's Exhibit 233 is a document produced by ARM. Do you see here an email from Jonathan Craycraft, who was in the finance department at ARM?
Yes.
All right, and he's circulating quarterly presentations. We had seen a quarterly presentation from August. Now we're at towards the end of 2020 in December, correct?
Yes.
Okay. He sends it to you. Well, he sends it to Mary Cameron Carroll. Is she an admin?
She was admin.
Administrative assistant?
Yes.
Yeah. With copies to you and Mr. Tipton and to Sammy Morcos of ARM?
Yes.
And this is a year and a half almost a year and a half after ARM entered into the agreements with Medallion, correct?
Correct.
It is 8 months after the commencement of services on the Epic pipeline and at the Epic dock, correct?
Correct.
All right, we need to go to a page. You have the base number. Let's go back to a page in the presentation. Okay, let's come back to this one, and I want to come back and talk about this one when I can show you the page, because it's a very long presentation. Oh, you have it? Okay, so we're going to go to a page, and the base number is 18177. In this presentation from October 2020, you see this is a page from the presentation about the Medallion Epic pipeline.
Yes.
Okay. And the first bullet point says SCM is a gatherer into the EPIC pipeline. See that?
Yes,
SCM was Salt Creek Midstream, right?
correct.
At this point, ARM was no longer operating Salt Creek Midstream, right?
Correct.
ARM was removed from operation of Salt Creek Midstream by Ares in July of 2020 due to cost overruns, right?
I don't know the details, but that is the right time frame.
The next bullet point says SCM and not AEM had the relationship with the producers. Do you see that?
Yes,
Okay. Now, to be clear, Salt Creek Midstream, it was building pipelines for a long time under the operation of ARM in the Delaware Basin specifically, correct?
in the greater Delaware Basin, yes. Some of it was
Right.
not all of it was in the Delaware Basin.
And generally, and we'll talk more about this with other witnesses, but generally, the oil is lighter in the Delaware Basin. As you get west, it's lighter than it is further east around Midland, right?
That is
Can
correct.
I ask a question? Is there a Shakaria North Cross in this case? She's wanting to enter the room. I just want to see if she's involved in the case.
I don't know the name, Your Honor.
Shakaria North Cross? Anybody?
ARM doesn't either. We don't either.
I guess I'll admit her in. I don't know who she is, but okay.
All right, so Mr. Wishoff, we look at Salt Creek's not ARM having the relationship with the producers. The next bullet point says that AEM, ARM, was able to lay off much of the risk with Lillis, who went BK. Do you see that?
Yes,
Bankrupt, right?
correct.
But AEM itself did not have any other base customers in the area, correct?
That is correct due to the AMI that we had with Salt Creek. We were able to do the Lillis deal because post Salt Creek, after paying Salt Creek their fees, Lillis was looking to sign an MEH deal, related deal. And at that point, we were allowed to take a handoff on the pricing because Salt Creek did not price that way.
Let's break that down. What is an MEH?
Sorry, MEH was the Magellan East Houston coastal crude pricing. So, I'm sorry, Judge. Okay, keep going. So,
I think sometimes you're talking with, you have to understand, I'm the one making the decision here. I don't live in this world. And so you use a lot of acronyms that sometimes I don't get. And so if you could try not to do that, because it makes it a little harder for me to follow. So what does MEH have to do with this?
MEH was the Magellan East Houston pricing that represented the Gulf Coast. And Lillis was looking for a price in the Permian Basin based off of that coastal price. Salt Creek was in the business of transporting crude for a fee. When Lillis wanted to lock in it's like a hedge. They're looking to lock in a price for their crude oil. They passed them on to us, and that's when we did that Lillis deal.
Okay.
So Lillis was the only base customer ARM had in the area, correct?
Due to our AMI, that's correct.
Due to the AMI with Salt Creek.
And that ended
But
in
Salt Creek,
2020.
I'm sorry, go ahead. I'm sorry.
I'm sorry. And when the operator ended in July of 20, we were free to go talk to other customers.
Right. But the agreement with Lillis had predated that, right? Because by the time you get to July 2020, Lillis was bankrupt and that deal was over, right?
Correct.
Right. So prior to July 2020, ARM's only base customer in the area around the Salt Creek gathering system out there where the oil is lighter was Lillis, right?
Correct.
Right. And ARM only had Lillis because Salt Creek allowed ARM to have Lillis as a customer, correct?
That is correct.
Right. Salt Creek, operated by ARM, allowed ARM to have one base customer, Lillis, in the Delaware Basin area around the Salt Creek gathering system, correct?
I can't remember. I off the top of my head, I believe there may have been several deals. Obviously, this is the one we're discussing.
Okay. And then the next bullet point says that AEM is now wearing the risk and finally gaining traction in filling the capacity with non-MSA or FIN clients. Do you see that?
Yes.
And again, this is a year and a half after entering into the agreements with Medallion, right?
Yes.
I move admission of Defendant's Exhibit 233.
Any objection, defendants 233?
No, Your Honor.
233 is admitted. Are you almost done with this witness? Otherwise, I want to take a break.
Your Honor, I have probably no more than about 15 to 20 minutes.
Let's go ahead and take our morning break and we'll reconvene in about 10 minutes.
Thank you, Your Honor.
We had a couple new people join the Zoom, Shakaria Northcross, and then Alan Jacob. Are you here for this case or something else?
Hi, Your Honor. This is Shakaria Northcross. I am here because our firm, Jackson Associates, received an email from the court asking us to contact the court as soon as possible, and the link was pasted in the email, and so I logged on because I wasn't sure if they wanted me to log on to Zoom or to call.
Okay, let me go get Rhonda. I don't know what that's about. What did it say what case this was about?
Yes, it's for Calvary versus Dusty Smith.
I do apologize, sir. I didn't mean for her to actually to hop onto the Zoom link. I just want her to call me. We're showing that the attorney for you, let's see, Attorney Jeffrey is supposed to be the attorney for Dusty Smith on that case, but she's saying she doesn't have an attorney, and whenever we try to call, it's giving us a disconnected number. So I'm just trying to see if you guys really were representing her, because we never received a withdrawal motion or anything like that.
She did let us know that she no longer wanted us to represent her recently, and so we sent her over documents to sign so that we can withdraw. However, she has not signed those documents, so we have not been able to file the withdrawal as of yet.
So Ms.
Okay.
Northcross, just so you know, because this is sometimes attorneys don't always know this, is that there's three ways you can file a motion to withdraw. One is if there's client consent. Second, you can do under the local rules a 10-day letter, attach it to the motion to withdraw, and then usually we can do the hearing, or you need to set up for hearing. And so you don't have to get client consent. She's told you she wants to terminate you, so you need to file a motion to withdraw doing one of those three things.
Okay, thank you, Your Honor.
All right, thank you. Have a great rest of your day.
You too. Bye.
Thank you. Bye-bye.
But yeah, she's still counsel, Rhonda. And then Alan Jacobs, are you here for this case?
Yes, Your Honor, Dr. Jacobs is an expert for ARM.
Okay, we'll see you guys in a second. I notice you're coughing a lot. Something that I've been doing, I don't know if you have the same thing I had, is I take Mucinex and it really helps a lot.
Because you're still on live on YouTube.
All right, guys, you there? Can you hear me okay?
Yes, Your Honor.
Mr. Carter, are you there?
Mr. Carter's coming right back.
That's okay.
Just a moment, Your Honor. Mr. Carter.
Apologize, Your Honor.
Okay, you ready to get going?
In December 2020, there were discussions among you, Guy Freshwater of Glencore, and lawyers for Glencore and ARM about the agreements with Medallion, correct?
I don't recall the time frame. That sounds about right.
Let's look at 273.
I can't hear.
You got to speak up, Mr. Carter, or something. Something's wrong with your sound.
Yeah, I'll move the microphone closer. Is that better?
That's much better.
Thank you. You see that Exhibit 273 is a chain of emails from December 18, 2020 among Casey Burlage at Glencore and some other folks.
Yes,
Mr. Burlage is an attorney at Glencore, right?
yes,
And then there's Dave Cook and Gabe Newley, who I think we talked about before, attorneys with ARM, correct?
correct.
There's you, and then Mr. Freshwater and Mr. McDonald from Glencore. Do you see that?
Yes,
On the middle of the second page of the document, do you see that there's an email from Mr. Burlage to Mr. Newley on which you're copied that is dated Friday, December 18, 2020?
yes,
And Mr. Burlage of Glencore writes to Gabe Newley of ARM, Gabe, thank you for sending across the October 14 letter from Medallion, which we will review. We are also in the final stages of reviewing our files collected in response to Medallion's requests.
yes,
You recall that Medallion had requested information from ARM and Glencore in connection with ARM's and Glencore's complaints in their October 5, 2020 letter.
yes,
Mr. Burlage then suggests a call to discuss the legal issues the following Monday, correct?
yes,
Since he sent this email on Friday, December 18, the following Monday would be Monday, December 21, 2020, correct?
yes,
And then if we see up above that and onto the first page, going to the prior page, you see that Mr. Newley says that time works. He's going to send a dial-in, right?
yes,
And then Mr. Cook chimes in too that time works for him too, correct?
yes,
Your Honor, I move admission of Defendant's Exhibit 273.
Any objection, 273?
No objection.
273 is admitted.
Let's take down Defendant's Exhibit 273 and put up Defendant's Exhibit 72. Defendant's Exhibit 72 is a chain of emails between you and Matthew Hubert at ARM, correct?
yes,
At this point, Matthew Hubert was responsible for buying crude oil in the Permian Basin, correct?
he was our Permian trader, yes,
The chain of emails are from the morning of December 22nd, 2020, correct?
yes,
This is the day after the lawyers were supposed to talk, right?
I would assume that to be true, yes,
At the bottom of the first page here, Mr. Hubert emails to you more info from Epic via SCM, Salt Creek, stating they aren't in WTL service. Do you see that?
yes,
He then asks you, do we still want to try to nominate something for February, correct?
yes,
You respond up above that, I want it done in January. I can't make the call today, but ask Glencore to nominate then, please, correct?
correct,
You told Mr. Hubert to ask Glencore to make a nomination to Medallion, correct?
correct,
Mr. Hubert then responds to you and says, we can ask them to do it, but Epic would just say the nomination for January is invalid since it's after the nom deadline. That's why I was assuming February. I can ask them to submit it for January, though. Do you see that?
yes,
And do you recall that there was a nomination deadline of roughly the 15th of the month prior to the actual shipment?
yes,
Okay. You wanted Mr.
Hubert to ask Glencore to nominate WTL specifically, correct?
I don't know if I see that, but yes, that would have been what we were talking about.
All right, I move admission of Defendant's Exhibit 72.
Any objection?
No objection.
Defendant 72 is admitted.
All right, let's take down Defendant's Exhibit 72 and put up Defendant's Exhibit 138. Defendant's Exhibit 138 is an email from Aaron Dunn of Glencore to the crude scheduling at Epic Midstream, and this is from January 2021. Do you see that?
Yes.
There is an attachment to this document, which is a series of spreadsheets, and I want to ask you about one of them specifically, and it's the Revision 2 tab. Okay. Do you see that there was a spreadsheet in this document of a Glencore nomination that on December 22nd, 2020?
Yes.
Okay. And you see the sources of crude oil that are being nominated on December 22nd, 2020 by Glencore, correct?
Yes.
And you see that of the 27,300 barrels per day that are being nominated for transport in January, only 7,200 barrels per day are coming from ARM, correct?
Correct.
Most of the volume listed on this nomination by Glencore is from suppliers other than ARM, correct?
Correct.
You testified yesterday that ARM had shortages in what it had committed to supply Glencore in October and November of 2020. Do you recall that?
The volumes that were flowing came up less than they were supposed to be.
Right. And that ARM also had shortages in what it committed to supply to Glencore in December 2020 and January 2021, correct?
No, I believe those were October and November shortages, and they were resolved in the November and December flow months.
The nomination includes, that we are looking at, includes 2,000 barrels of WTL, correct?
Yes.
Right, and this is on December 22nd, 2020, the same day as your emails with Mr. Hubert, correct?
Yes.
Are you aware of any prior nominations of WTL using this capacity?
WTL was never accepted, so we never made a nomination.
The WTL, the nomination includes a receipt location. Do you see that?
Yes.
And the receipt location that is listed for the WTL 2,000 barrels is Wink, correct?
Yes.
And you recall that we looked at that March 8, 2020 email from Epic saying that Delaware Crossing was looking to commission with WTI only?
In April of 20, that was correct.
All right, and you're not aware of, we already discussed that you're not aware of the what the Delaware Crossing tariff specified in terms of what types of crude oil it could deliver, correct?
No, we were not a shipper on Delaware Crossing.
I'm sorry, you'll have to repeat that for me. I didn't catch that.
We did not have a contract where AEM was the shipper. I'm not intimately familiar with their tariff.
Right. You don't know whether Delaware Crossing offered WTL service in its tariff as of December 2020, correct?
Most gathering tariffs are to the most stringent qualities, and then they offer subsequent capabilities via crude oil gathering agreements or COGAs.
Okay. And you see that the connecting carrier listed is Delaware Crossing for the WTL, right?
Yes.
Okay. I move admission of Defendant's Exhibit 138.
Any objection, defendant 138?
No objection.
Defendant 138 is submitted.
Okay. And let's look real quick at Defendant's Exhibit 76. Defendant's Exhibit 76 is the Imperial Crude Intrastate Tariff containing rates, rules, and regulations governing the intrastate gathering and transportation of crude petroleum by the Delaware Crossing LLC pipeline. Do you see that?
Yes,
And this is from an effective date of June 12, 2019. You see that?
yes,
We look on page 5. You see that the specified quality of crude oil from this pipeline is API gravity of 36 to 44.
yes, that is the gravity. We aren't looking at the whole document, but I assume it says somewhere in here that COGAs or crude oil gathering agreements can have other specifications as well.
The Delaware Crossing tariff specifies WTI, correct?
In their base, most stringent form of tariff, yes.
And you do not see anything here saying that WTL service was part of the quality specification for the Delaware Crossing tariff, correct?
Not in this box.
Last witness, Your Honor.
All righty, any redirect?
Yes, Your Honor, I've got a little bit. First of all, is Delaware Crossing, is that a pipeline or a gathering system?
It is a gathering system.
The gathering systems operate differently than pipelines?
Yes, they are not long haul transmission. They are gathering systems that go back to many, many points and take many qualities across the pipe.
It's kind of a spider web in the area where oil is being produced and its pipes going all the way out to the various producing wells, right?
That's correct.
And you mentioned some sort of agreement.
COGA, which stands for Crude Oil Gathering Agreement, which is the ends up being the contract that the shipper their details are in.
Okay, I want to.
Can you give me the acronym for the COGA? What are you saying?
Crude Oil Gathering Agreement.
And if we look on, it's page numbered 1, but it's the third page of Exhibit 76. We see them defined, and I'm sure we'll see something further in the agreement.
Plaintiff 76 or defendant 76?
This is defendant 76.
That has not been admitted yet.
Your Honor, I neglected to ask to move to admit Defendant's Exhibit 76. I would like to admit Defendant's Exhibit 76.
Any objection, defendant 76?
No, I thought it had been admitted. I apologize.
76 has been admitted. That's okay.
All right. All right, let's talk a little bit about some fundamentals of the trading and marketing business that I just want to make sure are clear. We've talked about the spread between Midland and what you referred to as MEH, which I think you told the court was a Gulf Coast number.
Correct.
Could you take that down? I just want to get a sense, as a marketing, as someone who engages in the trading and marketing business, how is that MEH number calculated and available to you as someone who's engaged in this business?
So there's a publication called Argus. It's kind of like our energy newsletter, if you will. And they do a survey each month of the trades done in a certain location. And in this instance, Magellan East Houston is Magellan Pipeline in East Houston. And the weighted average of those trades becomes the price set for that month.
And when you say it's the price set, it's the price that you quote as the MEH?
That's correct.
And is it a price for deals that are just in that month?
That's correct. Just in that month at that location.
Okay. And maybe I didn't phrase it correctly, but is it the price for deals that where crude will be delivered at that location on that particular month?
That's correct.
What about a forward price? Is there a forward price published by Argus, and what is that?
Yes. So there is a forward financial market, which represents what that MEH, Magellan East Houston price will be in the forward months. So it is a financial contract that will settle against that MEH Argus price. So it's a representative forward price today of what Houston crude oil is trading delivered to that location
Over a period of time?
over a period of time in distinct months. Each month has an individual price.
And is that published by Argus also, or is that forward contract? How do you get the numbers for a forward contract?
Yeah, and the forward contract, those are in the financial markets. So ICE or other exchanges that offer that contract, NYMEX, they have that forward financial contract.
And when you refer to ICE, what is that?
Intercontinental Exchange, which is an financial clearing exchange.
And where is it located?
It is an exchange located in New York.
And you referred to NYMEX. What is NYMEX?
The New York Mercantile Exchange.
Okay, and I suppose that's in
Located
New
in New
York.
York, yes.
Okay. So, so when you're looking at a deal, and you're trying in Corpus Christi, for example, is there a published price, like the Argus, MEH price for Corpus Christi?
There's not a marker for Corpus Christi that is liquid, which means available, if you will. It's not an available Corpus Christi price.
And is there a Corpus Christi forward contract that takes you out a number of years and projects a price on any given date for each of the months and a number of years forward?
Not that the market uses, no.
Okay, so if you're doing a deal in Corpus Christi, why are you looking at the MEH price like you did here?
The MEH price is the price that we can see. I used this word earlier. It's defensible to our investment committee. It is a representative price that we can show to our investment committee, and we're not going to argue over what is that price because we can show them this is what that price is.
Okay, and to the extent there are forward contracts at MEH, how far out do those contracts go?
They can be quoted for up to 5 years. They trade availably probably in 2-year increments.
Okay. And so when you were evaluating this deal and you were using an MEH price, were you looking out 2 years or 5 years, or what were you doing?
We were taking the 5-year estimate of those 60 months.
All right. And we also talked about a Midland price. What is the Midland price?
Midland price is similar to the discussion we just had. It is an Argus price that settles each month, and there is an available estimate of forward months of what that would look like.
And is that because there's a traded on the NYMEX or ICE forward contract that's based on the Midland price?
That is.
All right. So when you were evaluating this deal, and we saw some documents where you were looking at the difference between the Midland price and the MEH price for the term of the contract, was that a price, or was that price differential the differential that you knew you would achieve throughout the term of the 5-year contract?
No, this was an estimate of what a financial forward, let's say this would be an estimate of those forward financial contracts at a point in time.
And are there ways? Well, let's look at the document. I believe it was Defendant's Exhibit 221. And this was a document that Defendant's Exhibit 221. which is a document that you were asked about by Mr. Carter. And it was a 12/16/2019 analysis prepared by Mr. Sarman to you and Taylor Tipton. I'm sorry, did I? And if we can look at the page that you were shown by Mr. Carter, I believe it was the 18th page, which is page number 14. Excuse me, the 16th page. All right. It shows medallion scenarios, total current market value. Do you see that?
Yes.
And where did you get these various numbers going through the term of the contract in January of 2025 for that current market value?
Those were the financial instruments we were just talking about for MEH in Midland. And then we used Brent. Each of those has a price 5 years forward that we used as a marker for this intrinsic value.
Okay, so this is valuing. This is the Brent scenario?
This has some Brent in there, yes.
Okay, well, that introduces something new. We've talked about Midland, we've talked about MEH. Let's talk about Brent. What is Brent?
Brent is the, like we were talking about MEH and Midland, there's a forward estimate of pricing. Brent is the representative crude oil price in the North Sea. And it is a very available contract with a fairly good price discovery that is a defensible number to give to our investment committee.
And that's the price that you can buy Brent crude in the North Sea?
Correct.
Or for delivery in the North Sea?
It's crude oil production in the North Sea.
All right. And to the extent that you're looking at Brent, does that mean you're planning on selling the crude at Brent?
No, we would not sell at Brent. We would sell in Asia, Latin America, Europe, et cetera.
Are there visible prices for Latin America, Asia, and some of these other places you were talking about?
Not like Brent, not a 5-year available defensible number.
All right, let's look at the page before that. Just page. Now, what is this?
This is, we typically, what we do is we show our investment committee a defensible conservative number, and then we show them the possible outcomes or scenarios throughout a deal. This is the low value scenario of the medallion capacity.
And what was the low value?
The low value was if we did nothing, 67, I guess it says 68.47 million.
And that would be a loss, right?
That would be a loss.
And was that a risk of loss that ARM was knowingly taking in this deal?
Yes, it was.
Why do you take on a risk like that in doing a deal like this?
We believe that the reward was better than the risk. There were, as we talked about yesterday, good optionality, delivery location capabilities, and quality over a 5-year period, so time as well. We were willing to take on that risk.
All right, and at least during the first several months of the contract, after it became effective or commenced in April of 2020, did you have a high case, a low case, or the median case?
As this came on into the we started up during the pandemic. We were trending closer to the lower case than the high case.
Did that mean that you would be at a low case throughout the entire 5-year term of this contract?
No, 5 years is a long time, and many things will change between the first days of COVID and year 5.
All right. Now, when you talk about the risk that you were taking on was that the demand charge that you were paying the $1.50, which was, I think, $1.35 for the transport from West Texas to Corpus,
Correct,
and 15 cents for the terminal fee.
correct.
Okay, and that was something that ARM paid, not Glencore.
Correct. We reimbursed Glencore.
So to the extent Glencore actually made payments to Medallion, you guys reimbursed them.
Correct.
And was Glencore in any way on the hook for those charges?
No.
Now, talk a little bit about SCM. I mean, you make money in AEM by taking on this risk and seeing what opportunities present themselves in the marketplace, right?
Correct. We take title to the commodity and we take risks that we may make or lose money.
Does SCM do that?
No, they are an infrastructure company that takes lease payments.
So they're just paid a fee.
Correct.
It's like owning an apartment building, right?
Correct.
Do they actually buy the crude?
They are not crude buyers.
They don't take title to the crude.
There may have been an example, but that's not their core business.
All right. I'd like to look at Defendant's Exhibit 230. And this was a presentation that you sent in August of 2020. And I believe Mr. Carter asked you some questions about this.
Yes.
So this is August of 2020, August 31, 2020. And I believe let me see. I believe he asked you about the 32nd page. If we could blow that up, Brian. Okay, you recall discussing this with Mr. Carter?
Yes.
All right. You wrote, I'd like to focus on the middle part on the left-hand side where it talks about market dynamics.
Yes.
Now, this is in August of 2020, and I believe yesterday you said that things were starting to stabilize around this time frame.
Yes, we were seeing improvements across the board.
Yeah, and in this presentation, you wrote, market dynamics are subject to change and improving headed into 4Q20. You see that?
Yes.
So that's consistent with what you said yesterday?
Yes.
And it says ARM or AEM shipped during April and May, and then did not ship in June. And in that second bullet point, Mr. Carter took you to the first part of that where you said you did not ship in June. But let's read the rest of that. It says, but covered all costs by hedging. Can you explain that to the court?
Yes. So we were just discussing the financial products, MEH and Midland. Those contracts, we were able to use those contracts. So in this example, we were to sell an MEH price and buy a Midland price financially and lock in a rate or a value that was wider than the demand charges we were paying for this capacity.
And,
So
did you enter into those financial contracts with Medallion or Glencore or producers?
no, we did that as AEM.
Okay. And then the last bullet point says margins in 4Q20 are substantially better. You see that?
Yes,
And was that the case at the time?
that was the case at the time.
And did that present opportunities to ARM and Glencore?
Yes.
All right. Mr. Carter then focused your attention on the next grouping of or bullet points where it says AEM has line of sight to 10 to 15 million barrels of per day of crude oil to be put into the JV finalizing terms. Do you see that?
Yes.
And your minimum daily quantity that you had committed to Medallion under the contract was 27,000 barrels per day.
27,778.
And I think we talked about this yesterday, but was between you and Glencore, were you guys relying solely on AEM to source the crude?
No, we were, especially in the beginning, we were relying on Glencore. Recall we had the Glencore, we had the credit fee for them to go out and procure barrels. And over time, we were looking to add accretive deals to the portfolio.
All right, we looked at during your cross, that second bullet point, AEM is continuing to evaluate opportunities to take the medallion liability off the balance sheet. Do you see that?
Yes.
Now, to the extent that, we saw those projections based on the forward financial contracts that showed that if you did nothing, you'd lose $68 million over the term of the contract.
Yes.
Is that potential for liability reflected on ARM's balance sheet?
We are an accrual-based accounting, so the forward value is not on there.
So that $68 million is not on your balance sheet?
It would be out there, but we recognize on our balance sheet each month. We are not mark to market.
Right. You don't recognize a full $68 million loss on day one.
On day one, correct.
Right. And do you know you're going to experience a $68 million loss as market conditions and improve over the course of the 5-year period this contract would have been in effect?
We were confident we would not face a $68 million loss.
Yeah. So to the extent there was something on the balance sheet, what was that?
The assurances that we were paying, the prepayment, so that was cash out of the door that pulled on our credit line, and then letter of credit. Well, as that was outstanding, that drew on our credit line. And so those assurances do reduce our capacity on our balance sheet and our borrowing line.
And to the extent that you have a partner like, what was Glencore's credit worthiness versus ARM's credit worthiness?
Medallion was asking us to prepay. Let's use the 18-month example that Glencore came in. We were to prepay or post during that time frame. Glencore, I don't remember exactly what their credit rating is, but let's say it's BBB or an A, and Medallion's happy to accept their credit. So when Glencore comes in, we are no longer required to prepay or post an LC, as they have reduced that balance sheet draw on our deal.
And just to be clear, you were required to prepay and post an LC even with Glencore, but it was less than you otherwise would have had to?
Correct. The Glencore deal was for 18 months when we signed it, so it was a reduction of 18 months only.
I see. And so to the extent that that terminated in 18 months, would you need to replace it with something else?
Yes, that's what we were talking about here, evaluating the opportunities to reduce that liability.
Okay, let's look up to the right-hand side where you talk about Lillis.
Yes.
It says Lillis base-loaded AEM's deal with Medallion, providing transport from Midland to the coast and ARB opportunities to the world. You see that?
Yes.
And by this point, had Lillis gone into bankruptcy?
Yes.
Okay, so the deal, I think that's with Lillis, was MEH, that's that Gulf Coast price, minus $4.95 through December 24. And you would have been purchasing from Willis in West Texas and shipping to the Gulf Coast, and that $4.95 would represent a margin?
That is correct.
Was that contract with Willis the hedge that you referred to that we were talking about earlier?
That was not the financial hedge that we were talking about in June, no.
Okay. And if that Willis contract had gone through the term of the agreements with Medallion, I guess what you're saying here is that would have covered at least 50% of that $68 million?
That's correct.
And to the extent Lillis went into bankruptcy, does that mean there was no way you would find other contracts during that 5-year term that would also make up some of that?
No, it does not. Just at that time, we lost the Lillis deal.
Now, there was some questioning about Lillis being in the Salt Creek the area covered by the Salt Creek AMI?
Yes.
And specifically, how did you go about getting that excluded from the AMI?
When Lillis was looking to, they were viewing this as a hedge on their part. They wanted a coastal price for their barrel. They went to Salt Creek. Salt Creek was not in the business of providing that service. So a Salt Creek employee, I believe, contacted Josh Sarman, who took the lead on the deal from there. Believe that Zach Lee and Nawal Navarese would have had to, discuss that deal and get it passed off as a exception to the AMI.
All right, I'd like to switch gears a little bit and talk about hold on a minute. Okay, there was some discussion about SCM, which was Salt Creek Midstream. Well, let's go ahead and put up that org chart. You remember we talked about this yesterday during your direct,
Yes.
and we have ARM Energy over on the left and ARM Midstream Management over on the right. And again, we talked about ARM Midstream ARM Midstream Management owned 3% of Salt Creek and Aries owned 97%.
Correct.
And did Aries dominate the board of directors?
They controlled, yes.
And were there employees within this ARM umbrella that worked exclusively for ARM Midstream in operating the Salt Creek business?
Yes,
Were there also shared employees?
there were.
And did you work for ARM, ARM Midstream?
No, I worked for AEM.
Were there times that you advised ARM Midstream?
I would advise from time to time, yes.
All right. There was some discussion about an email exchange between a scheduler at Epic and a guy named Mark Walter.
Yes,
Do you recall that during your cross?
yes.
Who did Mark Walter work for?
He was a midstream employee for Salt Creek operations team.
Did he at all work for ARM Energy Management?
No, he did not.
Did he have, well, what relationship did Salt Creek Midstream have directly with Epic?
Salt Creek and Epic, they had a parent private equity company that owned both companies, Aries, and Salt Creek had their own contracts on Epic.
And that was for transportation?
Correct.
And so to the extent we've talked about nomination of crude to go on a pipeline, and then there's schedulers at the pipeline that
Right.
they're interacting with to make sure that everybody's knows what's coming and knows what they're going to be receiving, right?
Right.
To the extent there was scheduling going on behalf of Salt Creek Midstream, who would be doing that?
Mark Walter.
And would he be dealing, did he do any scheduling in connection with the contract that AEM had with Medallion?
No, he did not.
Did he have any responsibilities related to Medallion at all?
No, he did not.
Did he have any responsibilities for AEM's relationship with Glencore?
No, he did not.
And to the extent there was scheduling going on under the Medallion contracts, you know, on the supply side, on the ARM Glencore side, who was handling that?
Glencore.
Was anybody at ARM Energy Management handling that scheduling?
No, we were not.
And to the extent that ARM, AEM, and Glencore are out working to buy crude from producers to ship, does somebody like Mark Walter have anything to do with that?
No, he does not.
Did anybody at Salt Creek have anything to do with that?
No.
There was some discussion, and I just maybe was confused by it, but there was some discussion early on in your cross about delays at Salt Creek, and whether that had some impact on the ability to source WTL for the Epic pipeline. Do you recall something like that?
Yes.
Were there delays that impacted the availability of WTL in West Texas?
When Epic's timeframe kept being slipped back and back and back, the producers needed a surety for a home for their barrels, specifically their light barrels. And as that happened, Plains created an interconnect. And being a shrewd company, Plains signed long-term contracts to buy all that crude. So there was crude on the system, but it was now going to Plains.
All right, and if you can tell the court what Plains is.
Plains All American is a large midstream and marketing company.
And are they a competitor of Epic's?
They are a competitor of Epic's.
And to the extent Plains contracted for all of that WTL in West Texas because Epic was delayed, would it have been possible to buy back from Plains
Yes.
WTL that it had contracted for?
Plains moves 2 million barrels a day. They are the largest in the basin, and they would sell WTI or WTL.
Excuse me a moment, Your Honor. I need to consult with my lawyer.
Mr. Wishkoff, on the company name Plain, can you spell that for me? I need to make sure I have it correctly.
Yes, Plains, Plains, Plains.
Thank you.
Yeah, just one other thing. There was some discussion about an arm entity investing in a Monument Pipeline,
Yes,
and that was after the termination of these contracts.
correct.
Was the arm entity able to do that on its own?
No, as we talked about with Salt Creek, they created a new entity and have a private equity backer.
And how much did the private equity backer fund for that project?
Between debt and the private equity, I believe it was 198 million.
And was some of it financed through debt?
Correct.
And what percentage ownership interest does that private equity firm own in that entity that ARM formed?
I don't know the exact numbers, but it is a very high number, like Aries.
All right, pass the witness.
You have anything else?
Very briefly, Your Honor. Mr. Wishoff, you testified that a Salt Creek employee contacted Josh Sarman about the Lillis opportunity. Which Salt Creek employee were you referring to?
I believe it was Ben Beckham at the time.
Right. Ben Beckham was an ARM employee, right?
He was an ARM employee as a Salt Creek operator. He was out and then became an ARM employee after the operatorship ended.
Where was Mark Walters' office at this time?
Houston, Texas.
Right. He was in an ARM office, right?
Yes, we're on different floors in the same office. Yes.
Right. You were in the same office, but you had to take the stairs to see each other, correct?
Correct.
Last thing, if we could just look real quick at Defendant's Exhibit 230. We may need that. You have screen. And specifically the page that was 18451, which is the one we've been talking about.
You recall, if we look at the bold line towards the bottom on the left-hand side, you recall that Arms Council had asked you about where it says AEM is line of sight. Remember he asked you about this line?
Yes,
He asked you that it says AEM is line of sight on 10 to 15 million barrels per day of crude oil, right?
Yes.
That's 1,000, right?
pardon me?
M there means 1,000, right? 10 to 15,000 barrels per day of crude oil.
Sorry, yes,
It's not
correct,
million,
correct.
1,000. Thank you. Oh, what's that? Oh, and then, sorry. Then underneath it mentions that Ben Beckham is the only salesperson actively soliciting barrels, right?
Yes, he became, like I said, after the operatorship ended, Ben Beckham became an ARM employee. Obviously, he had very good connections within that footprint, and he was then pursuing those customers that he had initially had at Salt Creek.
Ben Beckham was an ARM employee, and then when ARM stopped managing Salt Creek, he was no longer working on Salt Creek business, correct?
He was a ARM midstream employee. When the operatorship ended, he became an AEM originator.
That's when.
I have nothing further, Your Honor.
Is that it for this witness?
I believe so.
Okay. Let's do this real quick. First off, there's a few people who joined the Zoom, Brittany Ruyak and a couple other people. Is there anyone here on any other cases? Ms. Ruyak, does anyone know Brittany Ruyak?
Ms. Riak is with,
Yes, Your Honor.
You're with this case?
Yes, sir.
Okay, anyone here not with this case? Okay. Let's talk about some scheduling stuff. So is the